I'm Andy Hallaby. I'm a shareholder with the Greenberg Traurig Law Firm, where I practice intellectual property litigation, among other things. I'm a member of the Federalist Society's Intellectual Property Practice Group, its executive committee, and I'm delighted to welcome you to today's discussion on the injunction function: is IP law promoting markets for innovators and creators? Let me begin with a brief announcement on CLE. For those of you who are pursuing CLE, we remind you that to get credit, you need to sign in and out each day, once per day. Signing in and signing out can be done via scanning the CLE QR codes. Thus, if you're pursuing CLE and you've not checked in, please be sure to scan the QR code on the back of your convention booklet or on the CLE poster. If you've already checked in via the QR code, there's no need to recheck. Second, a word about the Intellectual Property Practice Group here at the Federalist Society. Among other activities, the practice group sponsors a variety of IP-related events, in-person and virtual, throughout the year, coordinates publication of IP-related pieces in the Federalist Society Review and on the FedSoc blog, and works with other Federalist Society practice groups on projects of mutual interest. If you would like to get involved with the IP practice group, please reach out to Nate Kazmarek or another member of the FedSoc staff. Finally, I'm pleased to introduce our moderator, and as you'll see, resident polymath, Judge Ryan T. Holte of the United States Court of Federal Claims. Before ascending to the bench in 2019, Judge Holte served as the David L. Brennan Associate Professor of Law and Director, Center for Intellectual Property Law and Technology at the University of Akron School of Law, and before that, as a law professor at the Southern Illinois University School of Law. Prior to entering academia, Judge Holte practiced as a litigation attorney with the Federal Trade Commission and as an associate with the Intellectual Property Practice Group at Jones Day and as a patent prosecutor at Finnegan. Before that, Judge Holte served as a clerk to Judge Stanley F. Birch Jr. on the 11th Circuit and as a law clerk to Judge Lauren A. Smith on the United States Court of Federal Claims. Before law school, among other pursuits, Judge Holte worked as an engineer for Agilent Technologies, Hewlett-Packard in Sonoma County. He is a co-inventor on United States Patent Number 9523773, Systems and Methods for Countering Satellite-Navigated Munitions, which issued in 2016. He's a widely published researcher and author on intellectual property-related subjects, including, as pertinent to today's panel discussion, deep and empirical study of patent assertion entity practices, as well as application of equitable remedies in patent litigation. He received his JD from the University of California Davis School of Law, where he served as a staff editor on the UC Davis Business Law Journal. He received his BS magna cum laude in engineering from the California Maritime Academy, where he was a first-class graduate of the California Maritime Academy Corps of Cadets, 3rd Engineering Division. Judge Holte.
Well, thank you, Andy. Let me just make sure. Can everybody hear me? We can hear you with your mic. All right. All right. There we go. All right. Well, thank you, Andy, for the long introduction, which I think we emailed about cutting short yesterday. But really appreciate everybody being here. I know that we're competing against the Second Amendment panel down the hall. For those who are in the room, obviously, they might have more fireworks than us, but we'll have to change that with a great discussion this morning on injunctions and patents and copyrights. So the plan for the program will be that I will read every speaker's introduction at the beginning of their remarks. I will then give them 5 to 7 minutes for opening remarks, and we'll hopefully have at least 30 minutes at the end for discussion amongst panel members and questions from the audience. So as Andy noted, this panel is about injunction function. Is IP law promoting markets for innovators and creators? And by way of brief introduction, I'll read our planned focus of conversation. In patent and copyright law, injunctions are now a subject of significant policy debate. Innovators say they are unable to stop predatory infringement. Creators say they are unable to stop large-scale piracy websites. If so, this undermines the rewards promised by the IP system and devalues the commercial assets that drive the global economy in new technologies and creative works. Others state that intellectual property owners use injunctions to hold up innovation or chill legitimate commercial activity. This panel will focus on the role of injunctions in facilitating or constraining commercialization of patented technologies and copyrighted works, and what the current state of the law portends for the future, such as in the development of next-generation innovations like AI and the use of creative works. Our speakers will begin with Laura Sheridan, the head of patent policy at Google, to my left. Laura has shared her views on patent issues in numerous policy dialogues, including testifying before Congress on the intersection of AI and patents. Her patent policy work is shaped by years of private practice experience in both patent prosecution, litigation, due diligence, and post-grant practice, including counsel at WilmerHale. As an active member of the IP community, Laura is part of the Intellectual Property Owners Association delegation to IP5 Industry, a group that engages on procedural harmonization matters with the IP5 offices worldwide. Laura also helped to form the New York chapter of CHIPS and is a member of the advisory board for the NYU Law Endelberg Center on Innovation Law and Policy. Laura studied mechanical engineering at Cornell University and received her JD from Fordham Law School. Laura will begin our remarks today with a discussion on AI development and how AI development is best incentivized through the patent system. We'll also examine the post-eBay data and innovation impacts. Thank you, Laura.
Thank you, Judge Holte. I am honored to be part of this event and panel on the important topic of injunctions and how to make sure remedies in patent litigation serve the Constitution's explicit goal of promoting innovation. And I'm speaking from the perspective of a company that was a startup in a garage only 25 years ago, and last year spent more than $39 billion in R&D. The importance of policies that promote innovation for companies of every size and at every stage of their development is deeply embedded within Google. The starting point for this conversation has to be the Constitution, which establishes our patent system in Article 1, Section 8, Clause 8. The Constitution says that Congress shall have the power to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. With this language, the Constitution gives Congress the power to create a patent system for the explicit and sole purpose of promoting the progress of science and the useful arts. In other words, innovation. What's absent from this view is that patent rights represent natural rights or traditional property rights. On the contrary, patents are to be defined by statute, created by Congress as instruments of economic policy in furtherance of innovation. Justice Thomas explained this point in the 2018 Oil States case, stating that patents convey only a specific form of property right, and that is a public franchise, meaning one that's defined by statute and not a core or traditional property right. As Justice Thomas also explained in the 2017 Teva case, patents have a regulatory effect that restrains the actions of others and free enterprise. And you can think of each and every patent as a government regulation. If you're interested in this topic, I urge you to read Paul Clement's paper on this called Patent Rights versus Property, the Framers' Understanding of Patents. So these fundamental principles should undergird our understanding of injunctions in patent litigation. So let's fast forward from 1789 to 2006, when the Supreme Court decided the eBay case, which dealt with this very issue. In a unanimous decision, Justice Thomas wrote that the well-established principles of equity that govern when a plaintiff can obtain injunctive relief apply equally to patent cases. The court held that equity law did not support a rule of automatic injunctions following a finding of infringement, which the lower courts had been applying to that time. To summarize, no special rules for patents when it comes to injunctions. So let's momentarily go back to the Constitution and its reference to the patent system providing inventors with an exclusive right to their discoveries. That is something that's often pointed to in support of automatic injunctions. But what the eBay decision makes clear is that the exclusive right that is granted to inventors, just like the exclusive right in any type of property, must be evaluated and remedied in accordance with the principles of equity. And for patent cases, this still means that the large majority of them result in an injunction. But the Constitution's reference to an exclusive right in no way requires an automatic, complete, and immediate injunction, regardless of the circumstances and ignoring equity. So now let's talk about how the patent system operates. This will help make clear why the balance and flexibility that eBay brings is so important. Every year, there are over 600,000 patent applications filed in the US, and around 350,000 patents are granted. Patent applications are allowable unless the patent examiner can prove otherwise. But each patent application receives on average about 19 hours of time from start to finish. These days, more than 50% of our US patents are actually granted to non-US entities. Huawei is at the top of that list. So the reality for innovative companies is that the large number of active patents creates something called a patent thicket. A smartphone and its use can implicate over 250,000 patents. These patents are held by thousands of different owners, many of whose claims overlap with one another. And because patent examiners are given relatively little time to do the very hard work of examination, in spite of the effort they put in, mistakes can be made. And one study shows that in software, up to half of the patents could be at least partially invalid. So you may be hearing that patents are akin to land. Aside from the Supreme Court's legal recognition that they are a public franchise, the reality of the patent system underscores how false this is. I personally would welcome changes to the patent examination process that bring us closer to that, with more reliability and clarity. And much of my own policy work is about proposing concrete improvements to move us in that direction, but it's not where we are today. So with this understanding of the scope and functioning of our patent system, let's look at how things are playing out in litigation and what has happened in the 17 years since eBay. The evidence shows that eBay is working in a balanced, flexible way that supports the Constitution's goal of promoting innovation. The large majority of infringement findings result in an injunction being granted. A study from 2019 comparing data before and after eBay shows a drop of just 4%, from 89% down to 85%. And the decline was largely due to denials of injunctions to non-practicing entities, or MPEs. And these are businesses that are, these are entities in the business of patent monetization. And the decline for MPEs makes sense. An MPE actually does not want to shut down a product. They want to maximize licensing fees. And the only reason the MPE seeks an injunction is to leverage that threat to shut down a product to extract more than the patent is actually worth. But if you're looking at operating companies, research institutions, and was that 5 or 7?
It was 6, but you still have one more minute.
Excellent. One more minute. But if you're looking at operating companies, research institutions, and inventors, the impact of eBay was minimal. But beyond the impact at the case level, we also have data and studies on the broader economic impact. First, overall patenting activity has substantially increased since eBay was decided, suggesting no discouragement from using the system. In fact, we have more than double the patents today than we did in 2005. A study from 2018 found no evidence that eBay harmed American innovation. And that study looked at patenting as well, along with R&D, venture capital, and productivity growth. When it comes to encouraging R&D investment, right now we are focused on ensuring US remains a leader in critical areas like AI innovation, and that our policies support unlocking the tremendous potential of this technology. And a balanced approach to patent injunctions, as we have today, is one of the many ways our patent policy can support this leadership and growth. I look forward to this panel's discussion. Thank you.
Thank you, Laura. I know I already have a number of questions to follow up on, but we will roll through the rest of the panel and perhaps some of those addressed. Next up to my left is Laurie Self, the Senior Vice President and Counsel of Government Affairs at Qualcomm. At Qualcomm, Laurie specializes in U.S. patent policy matters at the federal and state level. She's based in Washington, D.C., and also supports Qualcomm's government affairs initiatives to promote strong IP rights in emerging markets. Laurie's particular focus is to ensure U.S. IP laws and policies provide the necessary protections and incentives to support the company's R&D-driven business model. Prior to her arrival at Qualcomm in July of 2012, Laurie was a partner at Covington & Burling, where she chaired the firm's IP practice group. She's a graduate of Duke University and the University of Virginia School of Law. Laurie will share her perspective as a member of a company that invests billions of dollars in R&D technology, with patents being the driver of the investments. She will discuss injunctions. To what extent do we have remedies for users of technology to come to the table? And do we have a system of laws that provide adequate incentives for users of our technology in the United States and worldwide? Thank you, Laurie.
Thank you. Thank you. So if you know anything about Qualcomm and anything about Google's policy positions on patents over the last 2 decades, you know that I would take issue with a lot of what Laura was saying, other than where the intellectual property clause resides within the Constitution.
At least we can agree on something.
There is common ground. There is common ground there. But no, what I wanted to do is kind of take a step back and sort of explain the role that patents have played in Qualcomm's trajectory. And I think as you hear different points of view on these issues, and of course there are very strong divisions of opinion on these issues, and have been really throughout the history of our patent system, what speaks to those divisions often has to do with a company's business model and how they use patents within their particular business, and the nexus between patents and that kind of R&D equation, if you will. So not to say that anybody's right or wrong, but this is one of those issues where you really have to understand the role that patents, from our perspective, a property right, play in driving investments in innovation. So Qualcomm was founded in 1985. We were founded based on a theory of how wireless communications could be radically transformed, radically improved over previous generations of communications technologies without a particular product in mind. Our founders were academics, consultants to the defense industry. Our founder was one of the leading founders of UCSD Engineering School. So again, it was bridging that divide between the kind of basic research that you do at schools like MIT and the commercial sector, and finding technologies that would help transform a sector like telecommunications. So we were essentially that quintessential startup that relied upon patents as really the only asset to drive venture capital investments. That is true for the startup economy today. I mean, at least for those startup sectors that are very R&D intensive, and biotech is one of the kind of lead examples in this modern day. But as we moved forward as a company, our mission was really to create transformative technology that would drive a mobile ecosystem. We did not have a product in mind. We did not intend to use our inventions to sort of create a product space. What we were trying to do was create inventions, again, that would revolutionize mobile communications broadly. So if you think about that business model, patents for market-based companies are really fundamental. And again, if you think about the role of trade secrets or other forms of intellectual property, if you think about how we compete with companies in countries where there is large government subsidization of R&D, in a market-based economy, you really are relying on private sector investments in R&D and a intellectual property rights system that will incentivize those investments. So for each generation of cellular technology, you're talking about 10 years of R&D. That R&D leadership position leads leadership in standards, which again, when you think about cellular standards, that is another platform for ongoing R&D, another 10 years of technological development. That 20 years trajectory before you see full commercialization of a technology can only survive if you have a patent system that justifies those investments at the outset and allows a return on investment through the duration, if you will. And obviously the protection we see with patents is critical to that. We fund our R&D exclusively through patent licenses. We have global portfolios of patents, and when you talk about the so-called patent thicket, the way the market has avoided those concerns is largely through portfolio licensing, which occurs again on a global basis. We have about 140,000 pending and issued patents that we license globally. And that licensing ecosystem and the stability of that licensing ecosystem is very much dependent on the remedies that underlie our patent system. So injunctions, we do not view the injunction as a kind of sword we hang over the head of potential licensees. We view it as an incentive that brings large companies to the negotiating table. Qualcomm's a large company, but our licensees tend to be much larger than we are. And the only way you can encourage those companies to come voluntarily to the negotiating table to secure a license on patents, which again, publicly available in the standards ecosystem, you're basically teaching the world about the capabilities of your technology, how to utilize your technology. That dynamic only works if you have rules and remedies that encourage companies to voluntarily license as opposed to just essentially steal patented technology. Today, our key competitors in R&D are largely Chinese companies that do not have the same market pressures, the same systems of laws that we have in the United States, which again, it makes having a fair rule of law and a strong property rights system in the United States all the more important. The fact that we're able to secure license payments and agreements with Chinese companies, I think speaks to the fact that they recognize that there are international norms at play, including remedies that underlie patent rights. That whole equation starts to break down when you make it impossible to obtain injunctions. And the data that we've seen shows that eBay has actually had a dramatic effect on the ability to obtain injunctive relief. So it's not just a question of what we do in the United States and how that impacts litigation rates and remedies in the United States. It's how we maintain a global ecosystem of technology leadership where market-based R&D incentives are premised on patent rights. So I'll stop there. Thank you.
Thank you, Laurie. Next down the line is Professor Kristen Jakobsen Osenga, the Austin E. Owen Research Scholar and Professor of Law and Associate Dean for Academic Affairs at the University of Richmond School of Law. Now, I know Professor Osenga has much to say about what we've already talked about, but she will be transitioning into copyrights and trade secrets. Professor Osenga teaches and writes in all areas of intellectual property law, including patent law, antitrust, legislation, and regulation. After law school, she practiced at the law firm Finnegan, Henderson, Faribault, Garrett, and Dunner, where she worked on patent prosecution and litigation matters. She then clerked for Judge Lynn of the U.S. Court of Appeals for the Federal Circuit. She then entered academia, teaching first at Chicago-Kent College of Law, then at the University of Richmond, where she has served since 2006. Has also served as a visiting professor at Emory University and William & Mary School of Law. Professor Osenga received her BS degree in biomedical engineering from the University of Iowa, master's degree in electrical engineering from Southern Illinois University, and a JD from the University of Illinois College of Law, where she graduated magna cum laude. Some of Professor Osenga's recent scholarship focuses on patent-eligible subject matter, patent licensing firms, standard development organizations, patent law reform, and claim construction, but as I noted before, she will be focusing her at least introductory remarks on copyrights and trade secrets. With that, Professor Osenga.
Thank you, Judge. I'm going to tell you, the day we had the teleconference to decide who was going to talk about what, I missed the call.
Teach you not to do that again.
I am never, ever going to miss a planning call again. So I have the topic that no one wanted to cover, even me. So I will do my best to cover it. There's a couple of recent academic pieces in this space, not by me, that provided some helpful information, and Judge Holte promised me later I can talk about what I want to talk about during Q&A. So, okay, so some of you may be wondering why, as Judge Holte framed it up, we're talking about patents and copyrights. I'm going to tell you we're going to talk about trade secrets, but not trademarks. I'm going to cover trademarks very quickly at the end of my remarks because I think trademark also demonstrates a potentially viable path forward for some of the problems we're talking about today, but I'm going to start with copyright and then trade secret. So, not surprisingly, the eBay test has expanded out of patent law and is being used in all areas of IP and even other areas of law. Just like in patent law, the tricky part of applying the test is reconciling what is irreparable harm in any given situation, and also what is the public's interest. Particularly in copyright law, which is built around the same right to exclude that Laura mentioned, the inability to prevent ongoing infringement would seem to be an irreparable harm, and yet when injunctive relief is denied, it's usually on this prong, and oftentimes in conjunction with the adequacy of money damages. While some folks argue that the public may have an interest in getting more infringing stuff more cheaply and more often, there's also a significant public interest in having a well-functioning, reliable copyright system. Trade secrets, similarly, rests on an ability to exclude other people, although that's a little more bounded by the danger of reverse engineering. So let's start with copyright, and I'm going to talk about an article that Pam Samuelson published in 2022 in the William and Mary Law Review. I will also mention Pam Samuelson called me at one time a patent maximalist and thought it was an insult. It was not. She published this paper examining injunctions in copyright cases post-eBay, so I'm relying on her survey of that. I disagree fully with her assessment of what it means that all is well and eBay is amazing, but I will rely on her survey of the landscape. So copyright law prior to Campbell versus Akron in 1994 was pretty much like patent law prior to eBay. Upon a finding of infringement, injunction would generally issue pretty much like the Federal Circuit prior to eBay. Courts thought copyright owners were entitled to injunctive relief, denying injunctions only in cases where there were other inequities, such as unreasonable delay in seeking relief or the idea of de minimis harm against a backdrop of significant investment by the infringer. So for example, an infringing picture or two in a book where the real value of the book was the entirety of the text authored by the infringer. So between Campbell, which was notable because of a footnote that suggested that if there's parity or fair use and it's a closed case, you shouldn't get an injunction, in eBay, Professor Samuelson's paper noticed no dramatic shift. The injunctions would still generally issue. There was a few cases where injunctive relief did not issue, but there wasn't a groundswell following that note in Akron. So then eBay was issued, and no surprise, things changed, but it wasn't quite as drastic or instantaneous as it was in patent law. Post-eBay and copyright, courts still generally issue injunctions in simple piracy cases. When injunctive relief is denied, it's most often because the copyright owner hasn't established irreparable harm or the inadequacy of money damages. Of course, the courts also consider the other two things, a balance of the hardships and the public interest prongs, and those come up largely where the copyright claim and the injunction being sought is to protect a non-copyright interest, like somebody's reputation. We don't want this to be published because somebody's reputation is at issue, so we're not going to enjoin that because it's not a copyright interest being protected. So how is this working? Well, injunctions in copyright cases are seemingly working very well in areas of large-scale piracy, less good in gray areas. So areas where we have parity or sampling or a small portion of a bigger thing. Oh my God, this sounds like patent law. Those are the areas that are really tricky for getting injunctive relief in copyright. So the status of copyright is probably very similar to what we see in patent law. As far as trade secrets, things are even trickier there. Because trade secret remedies were governed by state law, often informed by the UTSA and brought in state courts prior to the Defend Trade Secrets Act in 2016. There are now, after that, significantly more federal trade secret cases, and so now I rely on another professor who has not insulted me in public, Elizabeth Rowe. She published a study in 2020, an empirical study on injunctive relief in trade secret cases, both before and after eBay. So traditionally, injunctive relief was available in trade secret cases where the plaintiff could not show monetary harm. And that was a pretty standard it would just issue. Although neither the UTSA or the DTSA require courts to apply eBay when assessing whether to enjoin a trade secret misappropriator, the factors that are raised by the courts, according to Professor Rowe's research, are very similar because they're just brought up as a matter of equity. Just like with all other areas of IP, the big split becomes whether there should be a presumption of irreparable harm upon a finding of trade secret misappropriation. Courts in general are still accepting that trade secret misappropriation results in irreparable harm. But one of Professor Rowe's more interesting findings is that oftentimes when an injunction doesn't issue upon a finding of trade secret misappropriation, it's because the trade secret owner didn't even ask. So how are injunctions working in the world of trade secrets? Well, it would seem they would work a lot better if trade secret owners would actually seek them. Finally, we'll wrap up with trademark law, which weirdly is, at least in my mind, the least property rights-based IP, which may have actually just figured out the answer to eBay before all the other types of IP. So specifically, the Trademark Modernization Act of 2020 addressed a split in the circuits about whether a finding of trademark infringement created a presumption of irreparable harm, or whether the trademark owner actually had to go forth and affirmatively prove irreparable harm along with the other eBay factors. And the TMA amended the Lanham Act to clarify there is a presumption of irreparable harm that applies upon a finding of infringement. Taking that factor out of the eBay test, whether we're in patents, copyrights, trademarks, trade secrets, would make it a lot easier to obtain injunctive relief, and I wouldn't mind seeing that adopted in all areas of law. And I will conclude my remarks there.
Thank you, Professor Osenga. Finishing up the panel with the other judicial pillar at the end, we have Judge John Holcomb from the U.S. District Court for the Central District of California. Judge Holcomb was confirmed to the District Court in September of 2020. Prior to his legal career, Judge Holcomb obtained a BS in engineering from MIT and subsequently served on active duty in the Navy from 1984 to 1989, with duty stations including the battleship USS New Jersey, with home port in Long Beach, California, and joint staff at the Pentagon. After military service, Judge Holcomb attended Harvard Business School and Harvard Law School, where he earned a JD MBA, served as a law clerk on the U.S. Bankruptcy Court for the Northern District of Illinois, and then practiced intellectual property law at IREL in Manila from 1994 to 1997, and Kenobi Martins as an IP litigator for the next 21 years. Immediately before Senate confirmation, Judge Holcomb was a partner at Greenberg Gross, where he focused on intellectual property and bankruptcy litigation matters. Judge Holcomb will share the perspective from the District Court on the issues discussed and will also provide insight into copyrights and the context of trade secrets. Thank you, Judge Holcomb.
Right. Thank you, Judge Holt, and I'm delighted to be here. I do want to say Happy Veterans Day to my fellow veterans. Today is Veterans Day. It's a little bit daunting to be on this panel with these pretty impressive lawyers, judge and professor. I was just a lowly IP litigator for some 25 years before I was fortunate enough to be appointed to the bench. And I think it would be helpful for me to explain what my perspective has been since I've been on the bench and how I got to where I am now. As an IP litigator, looking back on my career, I tended, not by design, but I tended to represent more plaintiffs than defendants, so I tended to be very friendly toward injunctions, permanent injunctions, and often couldn't understand why we didn't get a permanent injunction in my cases when I thought it was clearly called for. I was surprised when eBay came out in 2006. I think I speak for the patent community in general. We were very comfortable and with the pre-eBay view of the Federal Circuit, which was very favorable to permanent injunctions. And it came as a bit of a surprise to learn that it wasn't something that was automatic or nearly automatic in patent cases. But that was, well, let me put it this way. Some would argue that eBay was not a change in the law. It simply said, well, we're not going to have an automatic rule, but apply the factors. And if one reads Chief Justice Roberts' concurring opinion, one, I think, would come to the conclusion that's essentially what he was saying is, this isn't that big of a deal. We're saying textualist analysis. We're saying look at the statute, and it's a may. Courts may grant permanent injunctions, but it's not an automatic. But that's fine. There's a long tradition of granting those injunctions. And then there was the Justice Kennedy concurrence, where he expressed a somewhat different view, although he concurred in the judgment of eBay. He suggested there were some reasons why perhaps courts should not be so quick to grant permanent injunctions. And as Judge Holte has written eloquently in several articles, there's certainly an argument to be made that courts have, at least district courts, have improperly applied the Justice Kennedy concurrence and not looked more carefully at the actual holding in eBay. The actual holding in eBay was the district judge, Judge Friedman's view was not correct. He had a categorical denial of permanent injunctions under certain circumstances. That's one holding. The second holding was the Federal Circuit's view, as I just said, of automatic, nearly automatic granting of permanent injunctions. That's not correct. The third holding was that Continental Paper Bag is still good law. And Continental Paper Bag from, I don't know if you were going to talk about it, from 1908, is a holding that says it's, I'm paraphrasing, it's perfectly fine for a patentee to not be practicing its patented invention and yet obtain a permanent injunction. So that was actually the holding in eBay, those three key points. Anyway, so that was kind of my view coming to the bench, and I remember early on having conversations with some of my colleagues about judicial philosophy and injunctions, and I expressed, my view coming from private practice that they should be granted more frequently. And I got pushback from, from some very wise mentors, and one of the things that kind of resonated with me is if you grant an injunction, preliminary injunction or permanent injunction, you need to be ready to enforce it with force. You need to be ready, if necessary, to find a contemnor in contempt. I guess a violator of the injunction in contempt. And you need to be willing, if necessary, to put him in jail. If you're not willing to do that, think very carefully about whether you're going to issue a permanent injunction. So I think that informs the view of many district judges when they approach permanent injunctions. The other thing is I wanted to, kind of on the flip side, provide, as Judge Holte did in some of his scholarship, a bit of a defense of the district judge in eBay, Judge Friedman, in the Eastern District of Virginia, who denied a permanent injunction twice, once pre-cert and once post-remand. One of the issues that Judge Friedman expressed was a concern about how his court was going to be affected if he granted a permanent injunction. He expressed the concern, and again I'm paraphrasing, that his court would be inundated with post-judgment proceedings about whether or not there had been compliance with the injunction. And he used that as a reason to deny a permanent injunction. And again, I can tell you from a district judge's perspective, that is a concern. We have very limited resources. People are often surprised when I say, it's just, for your case, it's just me and one of my law clerks working on it. And I have about 399 other civil cases that I'm working on. So we're pretty busy. We don't have a lot of bandwidth. That having been said, I don't think it's a proper concern to say I'm not going to grant a permanent injunction merely because it's going to keep me busy going forward. And again, I talked to one of my colleagues about this when I first took the bench. I'll wrap up really quickly here. It came up in the context of a motion to remand. District judges, you'll not be surprised to learn, love to remand cases because they no longer have them on their docket. And there's some times when it's absolutely appropriate and required that you do that when you don't have jurisdiction. There are many cases that are kind of wobblers. Do you remand or not? And I remember having a conversation with a colleague saying, how do we think about this? I mean, I'd love to remand this case just to have it off my docket, but I'm not sure that that's right under the law. And he said, well, this wise judge said to me two things. He said, one, it's fine to note that and acknowledge it. You'd be crazy not to, and you'd probably be led astray if you didn't acknowledge that you would like to do that. So acknowledge it, put it aside, and then rule on the merits. So I think that's the best way to view that issue and best way to view permanent injunctions. So from a litigator's standpoint, I think keep in mind that your request for a permanent injunction, the judge is probably going to be thinking, if I grant this, it's going to be potentially a lot more work down the road. And keep that in mind. Do all you can do to help the judge by recommending language for the permanent injunction that makes it clear what is permitted and what is not permitted. All right, thank you.
Thank you, Judge Holcomb. It's always great to invite judicial colleagues on the panel. They do a wonderful job of summarizing previous work and writings that I've done, so appreciate that. Much better than academic colleagues from my previous life where they just spend the whole discussion disagreeing with you, as Professor Osenga mentioned other academics in her work. So I wanted to begin with allowing the panelists brief comments on other opening remarks that were made, and we'll begin with Laura. And I wanted to begin each comment process by posing a bit of a question. And with that, Laura, you, I think, had strong head agreement with Judge Holcomb's points related to Chief Justice Roberts' concurrence in eBay, that the decision was no change to the standards of patent law. However, I think, as you noted in your opening remarks, the statistics seem to show otherwise. Was wondering if you could share your perspective on any of the remarks that were made, and specifically any commentary on Chief Justice Roberts' concurrence in the eBay decision.
Thanks. It's a great question. I read eBay and that concurrence as really standing for a simple message. And the whole decision itself, the main decision, is just 5 pages. So it's really just saying, show your work. It wants the district court to demonstrate that the principles of equity have been applied in that case, and that the eBay factors have been gone through, so that you are showing how in this very fact-specific situation the remedy makes sense. And that really resonates, because that has been, the main takeaway for me from eBay is you just need to make sure that you are showing the work for your particular situation. So, looking at the way this has played out, I mean, the data has shown not much of a drop, from 89% to 85% in terms of the grant of the injunction. But what is really important when we're thinking about an injunction, this isn't an on-off switch, and that ties into what Chief Justice Roberts was saying about showing your work. This is not, yes, you get an injunction, no, you don't. It is, maybe the injunction needs to be delayed somewhat. Based on the specific facts of this case, maybe we need to tailor it in a certain way to allow, sell-off of all these cars that are already on dealer lots around the country. I mean, there is tailoring of these injunctions that happens that, thanks to eBay, it was a reminder to say, you just need to show us that this remedy is tailored to your specific case. So I think that's a very important thing to take away from eBay, and just generally in the 16 years since. It's about tailoring the remedy to the case that's before you. I think one other point, and maybe we'll get a chance to talk more about this later, because I could go on for a while, but this idea of parties not wanting to come to the table since eBay, it just makes bad business sense to not come to the table. We will pay more if there is a litigation. There is a study that shows the ongoing royalty rate that a company will pay if they end up having that infringement finding in litigation is 70% more than what they would pay if a deal could have been reached before litigation. And in the Eastern District of Texas, where a lot of these cases are found, it's 76% more. You have every incentive to avoid that situation if at all possible, because that doesn't even include the $5 million in lawyers' fees and discovery costs that are associated with the litigation, not to mention all of your engineers saying, why am I being deposed, and prepping for trial. So we want to come to the table. We want to do deals. We have a team dedicated to doing deals. It just makes good business sense to do so, and I expect we'll get to talk more about that dynamic later in the discussion.
One note of clarification, Laura. I'm not sure what you mentioned, but from my academic work on empirical numbers, my statistics showed that before eBay, district courts were granting injunctions between 94 and 100% of the time, with no difference between the type of entity, including non-practicing entities. After eBay, the statistics for a 10-year period after showed a general grant across all plaintiffs of 72.5%, and for non-practicing entities down to 16%. Does that cover the numbers that you mentioned? And it seems to me that that would show that there's significant impact on the eBay decision despite only a direction of show your work.
So I am looking at a 2019 study that was looking at the impact of eBay on what it calls high-volume plaintiffs before and after. And that was showing when I think that's sort of how it's trying to get at what is an MPE and the impact there. But the 2019 study did show just a 89% to 85%. I think the data, depending on exactly how it's sliced and diced and when it was taken, I think there is some variation. But just briefly on the MPE point, I think this is an important one too. I think the good thing about eBay is we really shouldn't try to put plaintiffs into buckets all that much, because it doesn't help. And eBay, because it is a flexible framework where the district court judge is allowed to look at the facts of the case and make a remedy that makes sense, calling an entity an MPE or something else is just not helpful. It's about, what is that particular plaintiff in your court doing with the invention? Have they been licensing it? Are they a startup? Are they, winding down? Who are they? It's not a black and white MPE, not MPE. So I think that is probably some of the variation in the data. Is just, it's not always that helpful anyway to try to qualify or classify these entities.
Great, thank you, Laura. Moving on to Laurie for some comments on other opening remarks that were made, and I'll just tee up perhaps a first question for you in addition to your opening comments. I believe that there's been some recent public discussion on perhaps a legislative, quote, fix to eBay that has come out of the Senate. Do you believe that there are legislative solutions that might be necessary in order to continue encouraging innovation?
So yes, there is. So if you, just to take a step back, and first of all, on the point about data, I think it's really, as we talk about data and statistics, you really have to drill down to the details of those empirical studies to really understand what they show. The research that we've seen most recently shows a really precipitous drop in injunctions. And again, it's not so much the result of Justice Thomas's decision per se, which I agree did not endorse categorical rules, either in favor or against injunctions. It was meant to be a flexible framework. Now, I think many, for the scholars in the room, they would argue that Justice Thomas got the case law wrong in terms of understanding what preceded eBay in terms of how courts historically granted injunctive relief. And one of the key points that has been made is that, prior to eBay, if you were successful in establishing the validity of your patent and infringement by the defendant, that there was a presumption in favor of injunctive relief. What we're seeing being proposed in terms of legislation is legislation that would restore that presumption. Now, and a presumption is just that, right? It leaves discretion with the court, but it does at least creates a greater opportunity for plaintiffs to receive injunctive relief in situations where the court deems it appropriate. And that, in fact, is why we're seeing less effect in the context of trademarks, because there has been legislation that affirmed that presumptive remedy in the context of trademarks. And we do support that legislation, by the way. I think what has been so challenging post-eBay is the way in which district courts have interpreted eBay. They have interpreted eBay as a kind of categorical rule. They have drawn clear distinctions between what they perceive as so-called non-practicing entities and commercial competitors. I think that is a real disservice, if you will, to the foundations of the patent system, which was meant to create incentives to specialize in innovation. In other words, it was meant to create a kind of grassroots opportunity to participate in our invention ecosystem, to give rise to entrepreneurship, to give rise to R&D specialists, to give rise to a diversified technology ecosystem, and that has really been, I think, a core strength of the U.S. U.S. innovation economy relative to other countries that, had very different forms of intellectual property rights. So what we've seen in terms of the post-eBay application by district courts of the Thomas opinion is what I think is so problematic and really needs to be remedied through legislation. The only other point I'd like to make, just to respond to the judge's comment about this perception that if you grant an injunction, you could be sending someone to jail. I first started working on U.S. patent policy. I had been an intellectual property lawyer for my entire career, but these issues around patent reform became hot and heavy in the time frame when, if you remember BlackBerry, when BlackBerry was king of the hill in terms of devices, there was a district court decision in which the court was threatening injunctive relief against BlackBerry, and there was this fear that everybody on the hill was going to lose their BlackBerry, and it created this kind of sort of fear, if you will, around the impact of an injunction. What was really happening in that case was the court was trying to do everything possible to incentivize the infringer to come to the negotiating table and resolve the matter without resorting to an injunction. And I think that is the role of the injunction, to create appropriate incentives, to avoid litigation, to ensure that parties who refuse to license are not allowed to continue making use of the patented technology, and to create a dynamic where owners of patented technology actually have the right to decide how to use that technology. If you do not have access to an injunction, you are essentially positioning courts as arbiters of compulsory licenses and rate regulators. You are allowing the court to displace the role of the market in determining the value of patented technology. And by the way, as we all know, litigation takes years before a verdict is reached and the damages remedy is available to a patent owner. If you're a small startup, it's almost impossible to survive that juggernaut. So I just think there's a lot of nuance to this issue that we really need to understand to put these issues in appropriate context. So I'll stop there.
Thank you, Laurie. Wonderful to have you summarize the rest of the academic scholarship that Judge Holcomb didn't have time for. So and my article on that was The Misinterpretation of eBay and Why, for anyone interested. Moving on to Professor Osenga. So I promised you a great opportunity to talk about patents in your follow-up remarks. So with that, I'll tee up. You have a recent published paper on efficient infringement. Could you possibly talk about your thesis there and how it relates to the eBay case?
I can, but first I want to make sure you do it right. It's efficient infringement. It is not efficient infringement. I did actually manage to get the law review to put it in scare quotes through the entirety of the article, and I'm very proud of that. In fact, I think I have a couple articles now. But efficient, I'm going to stop doing this. Efficient infringement, or as I would like it to be called, but nobody ever takes my suggestions, predatory infringement, is something that happens because of eBay. And so just a quick explainer on the idea of it. One of the functions that injunctions serve is to deter infringement. You don't want to start down a path of infringing, tool up an entire factory, get a whole, manufacturing and marketing system in place, and then find yourself to be enjoined. So if an injunction is on the table, you will probably think twice about infringing. You will probably negotiate a license if it's available. You may design around if you can't get a license. There's a number of good things that come out of the idea of being afraid of an injunction, but deterrence is one of them. But if you aren't afraid of an injunction, you might have an entirely different mindset, which is, if I just infringe now, I can pay later, which seems like a really good bargain if you're an infringer. And so you might never get sued and infringe for free. You might get sued and get a lower royalty rate. There's actually some, to Laura's point, to contradict Laura's point, there's actually some scholarship being done by Jonathan Barnett that says, no, actually in a lot of cases, when you go to court, the royalty rate set by the court is significantly lower than what would have been received during negotiation. So you may not have to pay anything. You may have to pay a lot less. At the very least, you'll have to pay it a lot later. Okay? And so this is why some people call this efficient infringement. It's actually really not a great thing. And so my paper looks at this and also talks about, well, when would it be that you would be afraid of getting an injunction versus when would you not be afraid of getting an injunction? So to Laura's point, that, yeah, sure, injunctions are still issuing in 70-80% of the cases, but to Judge Holt's point, there's two particular cases in which injunctions are not being issued. And there's empirical work on it, and there's theoretical work on it, and so basically eBay does set up buckets again. You don't get an injunction if you're a patent licensing firm. It's the 16-20%, various numbers depending on the articles you read. And you don't get an injunction if the patent that is being infringed is a standard essential patent because of the FRAND obligation, the irreparable harm, blah, 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 that the courts have decided. So if you fall into one of those two buckets, you are unlikely to be enjoined if you infringe, which then sets up this mental mindset that it might actually be better for you to not negotiate, not take a license, and just go ahead and infringe now and pay later. And so that's what my article is largely about, and I'll stop there.
Thank you, Professor Osenga. Moving on for commentary on other folks' introductory remarks, Judge Holcomb. I'll just leave it to you to talk about whatever you want on what anybody else has brought up.
I contemplated about whether to talk about this case or not. It's because it sounds a little bit like I'm patting myself on the back, and I really blundered into what I think was a pretty good result. So I had this pretty complicated copyright and trade secret case involving software. The plaintiff had one customer, the defendant, and wrote software and supported it for 20 years. There was a falling out between the companies. Plaintiff sued defendant. Long, complicated litigation, copyright infringement claims, trade secret claims having to do with the software, contract claims. It was very messy. Many other pieces. There were counterclaims. So finally went to trial. It was almost a 2-week trial, and plaintiff won. Got a pretty resoundingly positive verdict from the jury. Not all the damages plaintiff wanted or was asking for, but significant. And so I had many post-trial motions. I had equitable issues that I had to decide. I finally issued my decision and the judgment, and in the judgment I did grant a permanent injunction in favor of the plaintiff, which required the defendant to destroy all copies of the software. Now, well, that's the simplest way to tee it up. And I gave defendant 60 days to do that. Then there was a flurry of motions, ex parte applications on all kinds of issues. So I called the parties in to talk about all these post-judgment issues. Of course, the defendant was really not happy about the permanent injunction and had asked for a stay of that, etc. I got one of my colleagues to mediate the case. We came and we talked about what was pending. I got one of my colleagues to mediate the case, And pretty quickly, over the course of an afternoon, the parties came to an agreement obviating the need for the permanent injunction and substituting money damages. So, again, I'd like to say that that was the design, but it just kind of happened that way. So I guess that causes me to think that permanent injunctions are okay. I mean, in a patent case, follow the eBay factors. In a trade secret case, follow the DTSA and the UTSA. And when it's appropriate, issue the permanent injunction, because there certainly can be post-judgment discussions and remedies that are agreed to, resolutions that are agreed to between the parties.
Thank you, Judge Holcomb. So with that, we have a little bit less than 30 minutes left. I'll open things up to the crowd. I'll also open things up to the panelists to share any other short commentary first. Why don't we go back and forth if there is? So we'll go to the audience first, and if you could state your name and your affiliation before asking your question. Go ahead, Professor Keefe.
Sure, I'm Scott Keefe. I'm a law professor here in town at GW. I'm just curious, Laura Sheridan, if you could maybe amplify a little bit more. Are you trying to frame your conversation as an insight or an empirical claim about how kind of pernicious the error rate in the intangible asset market of patents really is? And I'm trying to kind of get some context around that. So, for example, for a company like Google, you depend upon a lot of intangible assets, ads, personal privacy, software. Are the error rates in those assets fundamentally, powerfully lower? You don't patch, you don't offer to sell me the fridge you know I already bought. Are you claiming I'm a unique customer, I get a lot of bad ads, but most of the ads are really good? Is it an empirical claim or is it an insight? So when the stock market crashed, should we have stopped enforcing property rights in equity instruments? When the mortgage market crashed, should we have stopped enforcing property rights in the contingent liens? When the debt market crashed, was President Biden mistaken in choosing to resort to emergency authority to not enforce student loans? Because after all, these are intangible assets written with written instruments that are either, I guess, way more or less error prone than patents, and he could have just simply said, by the way, don't pay those, no injunctions. Are the property right insights in those other intangible markets different or the same, or is it an empirical claim? Thanks.
So I think here what is really important in the way I kind of think about this issue is rights and remedies. And we, of course, have the patent right created by statute, by Congress. And so that is the patent right. And I've said, in my opening remarks, it's not a traditional property right. It is a public franchise consistent with what Justice Thomas said in oil states. And then you have the remedies. And the remedies for infringement of that right have to follow the principles of equity, and that's eBay. So there's no suggestion here that you are ignoring the rights or not saying that those are in fact rights. It's just that the principles of equity apply to them. The point around error rate, and I think you might be referring to my factual discussion of what happens in our patent system, that's really just to understand the landscape of patents in general. And frankly, if we want to have the analogy where patents are like land, which I think legally the courts have said they're not, but if we want that to be more true, then we need to get the patent system moving in that direction, because you can't have a 50% error rate and analogize that right to a traditional property right like land. I really do feel like we should be working to move in that direction. That's a different policy conversation. That's what is the agency doing and how can it improve and bring down that error rate? Because frankly, we have 65,000 patents, and I want the error rate to come down for the reliability of those too, for that investment. But that is a different conversation than, you know, yes or no to eBay. It's what should we be doing to make sure that error rate goes down.
Thank you. Any other notes on that from the panelists?
Can I just?
Yep.
Yeah, look, I think this sort of age-old criticism of patents that because there's the possibility of human error, they are not entitled to treatment as a property right. I think that is a fundamental misunderstanding of how property rights were envisioned, you know, by our constitutional founders. You know, with all due respect to Justice Thomas, I think he got it wrong in the oil states case. I think it was a statement of longstanding precedent in terms of the treatment of patent rights. And look, let's face it. If you look at the opportunities to challenge the validity of a patent now through the courts, through the PTAB system, I would argue that by the time a patent reaches a judgment of validity and infringement, it has gone through so much of a crucible of, you know, survival that it is as close to bulletproof as any other form of asset we can imagine in our economy. So this notion that because there's, you know, the potential for human error in the prosecution system, that somehow injunctions are inappropriate or treatment as a property right is inappropriate, I don't think that's defensible. So.
Any other comments from the panelists? No. All right. Next question from the audience. State your name and affiliation, please.
Ben Slifka, retired monopolist. I worked at IBM, Microsoft, and Amazon. So I'm going to ask about software patents. And by way of full disclosure, I was an engineer on MS-DOS 6. We got sued for patent infringement, and trademarks got involved, and I later got involved in a suit with copyrights at Microsoft. So I've had in-courtroom experience on these things. So I've got 20 years of experience investing in startup companies, and we're talking about innovation here. And the biotech firms' patents are super important because it takes an incredibly long time to create and validate that work. The software companies, on the other hand, none of my software companies have any patents, right? And so I wonder about software patents, and we didn't used to be able to patent software. That changed, I think, in the 80s. And I wonder if we should once again stop patenting software.
So I want Laura to have an opportunity to speak, but I would just, look, there's no question that different types of companies rely on different types of intellectual property. Some don't rely on intellectual property at all. I mean, again, I think you really have to look at the business model of the company, how it generates revenue, to what extent it relies on patents to support long-term investment in R&D and to commercialize that R&D. So, you know, we could have a day-long discussion on the different role of different types of intellectual property, including open source. The one thing I would say about this notion of let's just preclude patenting for software is that, you know, in our sector, the semiconductor cellular sector, there is no bright line between hardware and software any longer. And that is true in the biotech sector. I would argue it's true in probably most technological sectors. You are seeing a convergent, I hope you can hear me. You're seeing this sort of massive convergence between what we think about as traditional software development and hardware development and other forms of technological development. So I just don't think that line exists in a clean way. So that's the only comment I would make there.
And I strongly agree with that. I was going to make the same point around it's unclear what a software patent would even be today. And I think so much of what we are focused on in patenting that might kind of be in that vein is AI related. And those are tremendously important. I mean, we have one of the fundamental transformer patents in the space, and we view that as an advantage and something that's a good thing to do. So I think there's been a shift, especially with AI, quantum computing, and 5G, and this real focus on high-tech sector and the realization that patents are important. They're important also for doing deals with your competitors. You want to enter into cross-licensing arrangements. that you clear the risk of their portfolio while they give you fair value for yours based on its relevance to their products. So I hear discussion of that, but I think it's one of those things that's more theoretical, and then when the rubber meets the road, nobody actually wants to do that.
Found the second thing you better do.
Exactly.
Any other comments down there? All right. Next question, and remember to state your name and affiliation.
Yeah, Bill Wichterman at Covington and Burling. I'll give a question to Professor Osenga.
Not about copyright or a trade secret.
No, about patents.
Good.
Sorry.
Okay, I'm ready.
So there's been a suggestion, I think actually Laura, I don't know if Judge Holcomb as well, but that there's something of lesser value about NPE's patents than others. And I want to argue with that because I think that, first of all, there's great NPEs in history like Thomas Edison and others who I think it's a wonderful business model that we should be able to differentiate in an economy rather than we just have everybody thinking things up and making them. And heaven knows how many inventors would be terrible at making things or setting up a distribution system, but they're great in inventing. So that should be, I think, a sign of a maturing economy. But if we've devalued NPEs, the patents associated with NPEs, I want to suggest that has an upstream impact on investment, because investment is what provides nourishment for the whole innovation system. I actually am an angel investor on the side. I fully assume that 50% of my investments will go to zero. If I suddenly can't get and then we are often NPEs, where you have a model of hoping to be bought up, purchased by somebody. If suddenly that's not available and the same remedies are not available for infringement, that's going to have an impact on investment. And I'd love to have you just speak to that a little bit, Professor.
Okay, I can do that. As might be a trend, I actually don't want to call them NPEs. I would like to call them patent licensing firms, because I think that's what they are. I don't think you can. Let's not make it a derogatory thing. They do a good thing for the economy. They provide liquidity. In a lot of different situations. I mean, you brought up maybe there's a good inventor but a bad marketer, but there's also companies that fail partway through because of. I've actually written papers on this, so I could direct you to my papers on this. The way we were thinking about NPEs, especially when we're trying to say they shouldn't be entitled to injunctive relief, is treating them as a monolith when they are so very, very different, and there's all kinds of different patent licensing firms, and there's lots of reasons why people get into patent licensing. So we shouldn't treat them that way, but then even putting that aside, the idea is that they do provide patent liquidity, they do provide markets, which is good. And then the last piece, I will just highlight some future research of mine that's coming out, hopefully soon. Not really my research, an essay written on somebody else's research, is that what we're seeing in the post-eBay situation, at least according to some studies, is a increase in non-exclusive licensing over exclusive licensing, which again then really affects the value of the licenses. So it's not just about whether or not we give injunctions to patent licensing firms or not, but all patents are now subject to devaluing when injunctive relief isn't available, because it's affecting the negotiation in the market for all patents. So.
Thank you, Professor Osenga. Any other comments on this side of the table? No. All right, next question. State your name and affiliation, please.
Well, thank you for the panel, judges, professors, thank you. Please forgive my ignorance. I am not a law expert at all. My name is Thibaut Montfort. I'm CTO and co-founder of a startup called Flexi, so I'm no Amazon or anything. And I don't come from the US. I come from overseas. Our startup is based in the UK. And first, I'm really happy to see there are investors in the room. We'll definitely have a chat with you later.
Welcome.
Thank you very much. And after a couple of exchanges with my patent attorney over the phone to relay what you were saying on the panel, and because it will concern us later, at the dawn of writing our fourth patent, I was wondering why it was pretty hard for non-American companies to get an injection on an American company. And I was wondering if you believe or you see that there is some maybe protectionism over American companies and their patents coming from abroad, because we talked about, the whole theme of this panel is promoting the market, promoting innovation for companies, maybe inside the US, how are you seeing the situation from outside and coming to get an infringement or an injunction on an American company? Thank you.
Yep, thank you. Any commentary on international protection with foreign companies?
I was wondering if the judges on the panel had any experience. Look, I would just say, as I don't have direct experience, I would just say, as somebody who's worked on intellectual property policy issues across the world, it is a fundamental principle of the U.S. property rights system, intellectual property rights system, rule of law, that there is no discrimination based on the nationality of the owner of the right. To me, that is a really foundational principle, and if we start to deviate from that, and we have seen instances in other countries where you do see discriminatory practices, then I think that would be hugely damaging in terms of the integrity and credibility of our system of intellectual property. So that's just that's more of a policy position as opposed to real world experience, but that is, like I said, I think it's a fundamental precept of our system.
So how would you be able to explain that discrepancy in getting an injunction? I mean, I would have to check, but
I think we got to have you on the microphone, but
I was just going to say, I haven't seen any data that sort of distinguishes between nationality, but it's an interesting question. I just haven't seen any data on the point.
thank
I
you.
don't know, Kristen?
Any other comments on that? All right.
Well, one quick
Go ahead.
comment. Now, this isn't necessarily directly responsive to your question because you asked about patents, but I have seen in the trade secret context a greater willingness of a court to issue an injunction to prevent the dissemination of the trade secret internationally. Sometimes, really, depending on the nationality of the defendant. Because of there's just a concern that once the cat's out of the bag, it's you can't get him back in the bag. That's the wrong metaphor, but you know what I mean. So I think that is a concern, at least in the trade secret context, is. Because trade secrets are so fundamentally different from patent rights. In patent rights, you necessarily, at least you're supposed to disclose everything about the invention so that any person of ordinary skill in the art can make and practice the claimed invention. Trade secrets is just the opposite. It's necessarily something, a formula, a process that's not generally known. So the injunction, I have seen injunctions in international trade secret cases more readily granted because of that concern.
Thank you. Yeah, so that brings up a question that we were going to have, I think, for all panelists related to the growth in trade secrets and the strength in enforcing trade secrets. Is there any other commentary from the panelists on observations of a move towards enforcing innovation through trade secrets and the likelihood of being able to receive equitable remedies in trade secret enforcement as compared to patents?
I mean, I don't have a specific response to the enforceability question. I would just say that just to build on the judge's comments, trade secrets play a fundamentally different role than patents, in our innovation economy. I mean, patents are meant to not only incentivize research and development, but to enable follow-on innovation and to enable collaboration and building of commercial markets and sectors and to Bill's point, specialization. That is not, I will say, not easily achievable trade secrets. I'm not even sure if it is achievable because inherently a trade secret is meant to protect the competitive and economic position of a particular company, and obviously it has to be kept secret. So to me, it's, and I have heard certain, people speculate, well, the patent system is broken, but you always have trade secrets. And like in our sector, which is built on systems-wide global communications platforms, you would see a collapse of that kind of global framework if you were having to revert to trade secrets. So for what that's worth.
Thank you. Next question. Remember to state your name and affiliation, please.
Hi, everyone. Thank you for being here this afternoon. My name's Cole. I'm a law clerk. I'm down on the Fifth Circuit. I had a question relating to Judge Holcomb's point about judicial resources, and potentially, I've not been affiliated with the judiciary for very long, but I've already definitely seen kind of an incentive for trying to avoid actions that would, say, take one step forward and then 3 steps back with respect to actually terminating the dispute, as opposed to granting an injunction and then having a flurry of post-relief actions. And so, to the extent that we think judicial resources would be a problem here, and also to the extent where potentially we're concerned about uniformity in how eBay is applied. I would love to hear the panel's thoughts on something that has been talked about in the academic literature about the creation of a unified trial court. Obviously, we have the Federal Circuit, but a unified trial court for patent matters. And of course, there'd be Seventh Amendment, logistical problems with juries. But it is something our country has done with the Court of International Trade, and it's something Europe did quite recently with the Unified Patent Court. And I'd love to hear the panel's thoughts on that.
Just real quick, it's a fascinating idea. I think we've got people here who clerked on the Federal Circuit. The Federal Circuit was created in the early 80s, in 1982, for, I don't know if precisely this reason, but to make sure there's uniformity in the patent laws. And it's always fascinated me as somebody who practiced in the bankruptcy area and then later in the patent area, how in bankruptcy law we have dedicated bankruptcy courts at the so-called trial level, and then the appeals go to the general regional court, and in patent law it's the exact opposite. I'm not saying that's good or bad or right or wrong, but it's fascinating. So you raise a great question. I have no idea where we are in terms of potential legislation to address that.
I support national courts. Coming from one, at least.
I mean, as a political matter, I can't imagine there would be a path forward for that. Whether it's a good idea or not, I just don't see a political path.
Thank you. Next question. Yeah, name and affiliation too, please.
Hi, I'm John Farmer, and I'm with a small IP boutique in Richmond, Virginia. Let's talk about attorney's fees for prevailing parties. I believe that, I'm correct in saying, under patent, copyright, and trademark, they each have an exceptional case standard. And so you don't go into the case knowing that you're going to be able to cover your attorney's fees. And I can tell you that especially with many small and mid-sized IP rights owners, especially in the copyright and trademark space, that's really the game. You talk to your client, they say, what's it going to cost? And you tell them and you say it's probably an investment in your IP because your chances of recovering attorney's fees are not great. And then they just say, I'm sorry, it's just not worth it, I can't do it. And of course that flows backwards to the incentive to create those strong marks and those copyrights in the first place, because if they can be infringed willy-nilly for free, then what's their value? So I think you're talking about legislation today because you're talking about whether the patent law ought to be amended to make the presumption of the availability of an injunction available, if I understand you correctly. And as Professor Osenga pointed out, that's already been done in the trademark area. So if we're talking about legislation and we really want to encourage innovation, would you support making it mandatory that prevailing parties in IP cases recover attorney's fees, or if not mandatory, maybe there's a strong presumption of the recovery of attorney's fees? You can see trade-offs there, of course, but if you want to incentivize creation, that seems to be a very big practical hurdle.
One quick comment, I'm sure that my co-panelists have thoughts on this. In the copyright context, for a copyright owner plaintiff who has registered the copyright before the alleged infringement began, there's supposed to be, automatic is probably too strong of a word, but a presumption in favor of attorney's fees in favor of the prevailing party, even if it's the defendant who's a prevailing party. You're right, there's an exceptional case standard in the patent world, and something similar, I don't know that it's precisely called that in the trade secret world, but I just want to make that one observation about copyright cases.
Maybe a more general observation too. I mean, this topic does come up, and I think It's more broadly coming up in sort of the overall expense of litigation, which you mentioned. And I think there was a push, maybe about 8 years or so ago, to kind of look at the different ways litigation gets very expensive and how some of those different aspects like discovery and Markman, where you're having these very expensive moments in the case and how can you phase them to kind of better manage costs. That to me, I mean, that didn't go anywhere. There was a lot of conversation and it didn't end up, of course, with legislation. But I feel like from a policy standpoint, that's more where the conversation goes, just given our legal tradition being so different from one of, paying the other side's fees based on the outcome of the case. It tends to be more just how can we streamline the process itself so it's cheaper for both sides.
All right, next question, state name and affiliation.
Mark Stolnick. I'm in private practice in New York City. I'm not an IP lawyer, but I was a student of Judge Holte when he was a professor at Akron. I never thought I'd be asking an IP question before Judge, but here we go. It's more of a practical question going off of the ideas for a statute or legislation or fee shifting burden. It sounds like in my practice, in New York, there's the Southern District of New York's standing order for FLSA cases to have compulsory mediation upon the filing of the case. It's actually ordered by the judge or the magistrate judge once it's assigned. When I was hearing everybody talk about how everybody seems to think that mediation is something to at least consider, if not a good idea, for the districts that have a lot of cases filed, Judges District, Eastern District of Texas, could the judges, you don't require legislation for this, the court just has to make its own rules within that district, knowing that these cases are going to be filed, set up some sort of program similar to that, anticipating that injunctions are going to be filed, that these motions are going to be argued. There's several, in the Fair Labor Standards Act world, a lot of lawyers in New York who are happy to be the mediators. They're certified by the court in order to handle those cases. I'm sure there's a lot of patent litigators or semi-retired or of counsel who would be interested, and since COVID, a lot of these are being done virtually. And so the parties don't even have to meet at a specific location, and the mediations can be done with multiple parties. So I just thought about bringing that up and seeing what the panelists thought about it, because when I was hearing everybody talk about mediation, it sounded similar to what New York's done with labor cases, because there's just so many filed. Thank you.
Thank you, Mark. I'll also give a shout out to my class, my fall intellectual property class, tuning in online on this Saturday, so appreciate that. But, comments from the panelists on the mediation question?
Sure, I'll start quickly. My court requires mediation in all civil cases. It's for a patent case, for an IP case, it's up to the judge precisely when that happens. The parties, the judge will require one of three paths. One is a magistrate judge on the court will mediate the case. Second is you go to private mediation, pick who you want and pay him or her. The third is we have an ADR panel in the Central District of trained mediators. I used to serve on the panel when I was a lawyer. And of course, of the 50 or more panel mediators, many of them have IP experience, and that's free for your first half day. It's free, that is encouraged in my court. Rule 16 suggests strongly to district judges at every scheduling conference, status conference, talk about mediation and the prospects of settlement. And then you've got Rule 1 of the federal rules, which calls on the court and all parties to seek a resolution that is just, speedy, and inexpensive. So all of those things counsel toward mediation and seeking resolution outside of full adjudication.
Any other comments? No. All right. One more question. Maybe one more after this. Go ahead. State your name and affiliation.
Hi, Keaton Blazer. I'm a Berkeley Law student. Judge Holcomb, I was reflecting on your remark that there's some hesitation to impose an injunction out of fear of potentially a lot more work down the line. That got me thinking about venue shopping and how you can select your venue with the goal of obtaining that injunctive relief. Thinking about the ITC, of course, that's pretty much the only remedy available is that injunction. And I was wondering if the panel had any thoughts relating to a potential alignment of the standards under which that sort of relief would be granted. I know, of course, that there are standards relating to domestic economic activity and things like that in the ITC, but it strikes me as somewhat different from what is there at a district court. And would it be possible to align that? I guess, would it be politically feasible, perhaps a less ambitious version of the Unified Patent Court? Thank you.
I can tackle, that's a great question. I think there has been talk of that kind of alignment between ITC and district court. I think that would be a very, very, very hard thing to do, although I think a lot of folks feel strongly that would make sense. I think what we experience from an ITC standpoint is because it has the injunctive relief, it is part of pretty much every litigation campaign that we face. So even though you have a district court case filed against you, you will have an ITC case for that very reason, for the leverage that it provides. So I think a lot of the talk about alignment is because of that very issue, where you see this sort of duplicative litigation between the district court and the ITC that frankly is just kind of wasteful. But I think politically that would be a very, very difficult thing to do.
Can I just also say, and maybe this is sort of self-evident to you, but the statutory construct of the ITC and eBay are fundamentally different. I mean, there are no monetary damages at the ITC. So, Laura's right. Of course, this has been a long-standing kind of policy discussion in Washington. But to me, I'm not even sure how you would, import eBay into the ITC without fundamentally changing, ITC rules, remedies, et cetera. I think it's also worth noting that, if you look at the number of cases brought in the ITC, it's still very, very small. I mean, relative to district court litigation, and it's obviously an in rem proceeding. It's meant to address situations where you have infringing products entering the market and where there is not, kind of an efficient mechanism to address that situation through district court litigation. So I just think you have to be very careful about conflating two very different systems and potentially weakening an ITC that performs a very important role. So.
Thank you. So I think we're 2 minutes over, but my retired colleague, Chief Judge Braden, a quick question?
No, I don't have a question, but I have a comment on Ms. Sheridan, which is, and there's not been any differentiation on the panel between preliminary injunction standards and a permanent injunction standard. It seems to be blended. No small company is going to request a preliminary injunction unless they really think that they have a valid patent, because under the federal rules, you have to post a bond. And you have to post a bond to show that to cover any, in the event something's wrong. If people have faith enough to approach a federal district court judge to ask for a preliminary injunction, the judge really needs to take a look at that quite seriously, because they're saying, trust me, because I'm putting up all of my capital basically to protect my intellectual property protection. So that's one important thing. The second thing basically is Judge Holte's article really ought to be required reading in the baby judge school, because
That's why I gave closing comments to Chief Judge Braden.
Well done.
And if you call this number now, you get that and a steak knife or something. Because the district court judges have the power to continue to issue injunctions. And particularly, they need to have that power to stop efficient infringement, which is a rational and a perfectly valid business strategy. I mean, I don't fault the companies that are doing it for doing it, because they've been allowed to do it. It's the federal district court judges that are required to stop that, and they have that authority now. We probably could get legislation, but we don't need it. You have that power. Use it.
Thank you, Chief Judge Braden. Thank you to the panelists. I also want to say, as we close with a round of applause, to remind everyone of what Judge Holcomb had mentioned about today is Veterans Day. We thank Judge Holcomb for his service. I'll also note that All of his kids or kids' spouses are currently active duty. We appreciate their service. We appreciate the service of all those in the room and those who are not here. And with that, let's give a round of applause for our veterans and panelists. And have a great afternoon.